Hi, my name is Katina Michael, and I'm an Associate Professor at the University of Wollongong in the School of Information Systems and Technology, and I hold a sessional position in the Faculty of Law in the Centre for Transnational Crime Prevention. I'm proposing for AUPOV 11 a workshop that may take on a parallel track sort of feeling, where we investigate the social implications of POV as understood within the law enforcement sector, which includes policing and security professionals, as well as private investigators. I think what I'm really getting at here is, do we understand what the various implications are when we take video footage that may be location enabled of individuals within a public or private space. And more than a public and private space, I think I'd like to focus on a public and private context. Sometimes individuals out in the public view are engaged in private matters. It's a private context, and I'm wondering what the nature of point of view recording at that point is, and whether individuals within the law enforcement sector feel they require a warrant to film a private context in a public space. I think the line is very much blurring and becoming increasingly complex, and creating a whole bunch of dilemmas for law enforcement personnel on whether they can use POV technologies either in an overt or covert manner in the public space. I want to learn about how data is captured and transferred to a law enforcement secure storage area network, and how long the content is stored for, who might have access to that content, what logs are taken and audits on the stored communications, whether LIAs believe they require a warrant to take some kinds of POV, whether the law enforcement agency has an institutional policy, or they have, a privacy statement or a security profile setting with regards to the procedures that POV lends itself to when law enforcement personnel get involved in this kind of high-tech surveillance. I think what's happening at the moment is that the line is blurring between when a warrant is required and when a warrant is not required. We all know that POV can be used to provide evidence in a court of law for example, cybercriminals who are producing and distributing and creating child pornography and other content-related offence material. But we don't know when a law enforcement personnel agent has gone outside that limited boundary of what they can and cannot do with POV. I'm very much interested in talks from people in this particular workshop, which might take up about half a day, maybe 5 talks in total. A talk from someone in the law enforcement sector, a talk from an individual who sells this covert surveillance equipment, a talk from someone in academia who's in charge of a policing and security grant, for example, which looks at warrants within the law enforcement sector. I'm also looking for general citizenry responses for POV equipment, perhaps POV equipment that's been used on a citizen, and the citizen feels that it has not been warranted, or the law enforcement agent hasn't had a warrant to conduct the filming, or the tracking, or the tracing for that matter. So I'm interested in a whole mix of talks from a variety of stakeholders that could come together to offer some enlightenment on the topic of the social implications of POV, especially location-based POV, as used in the law enforcement sector. I hope the workshop proposal comes through, because if it does, we can provide the label of the 6th annual workshop on the social implications of national security, focusing this time on point of view technologies at AUPOV 11.